What was your personal view about the action taken in December 1998? Were you uncomfortable with that?
I gave legal advice at that time. I was personally involved. But looking back, I can see that the argument was strained. The revival argument was getting more and more controversial in itself, although again we used it in 2003. And the use of 1205 and 1154 is a little bit difficult. But it was, as I say, it was anyway different from the 2002 resolution.
But you thought that was a stretch?
It was a stretch.
Even then?
Well, then particularly,
yeah.
Yes.
And so it's really just a question of the nature of the incidents. Well, from what you've said, you took the situation in 2003 more seriously because what was involved was full-scale invasion rather than the air attacks of December 1998. Is that fair?
No, I think the two legal situations were different for the reasons I've given. That 1441 set up a new inspection regime and made it clear, in my view, that the Council had to assess whether there was a breach sufficient to justify the use of force, that it was for the Council to do. But even with that, 1205 was a bit of a stretch.
So you would disagree then with Sir Jeremy's view that he had got into a similar position?
Yes, I would, and I did read his evidence very carefully. He did say that the wording of 1441 was equivocal as to whether the Council had to take the decision or whether it was left to Member States. And again, we come back to, should we go to war on what even he accepted was simply equivocal.
Thank you.
If I can take you back one more time to the Attorney General's advice. On the 14th of January 2002, the Attorney gave the Prime Minister a draft of what eventually became his advice. And we heard from David Brummel that there was then subsequently he engaged in a long process, an extensive process of analysis, consideration, inquiry and discussion with a large number of people before he formed his final view. And those people, I think, if I remember rightly, included the Prime Minister, the Foreign Secretary, Foreign Office legal advisors, academic commentators and so on. Do you think it was appropriate and in line with established practice for the attorney to give what was intended to be formal law officer's advice in draft to its ultimate recipient, conceivably thereby opening up a process of negotiation about it?
I think that draft advice, as you say, it became his ultimate advice, except it came with a different result. I mean, his draft advice, his provisional view, was that a second resolution was needed, as I recall.
And that was, you were informed of that draft advice?
I was shown it unofficially.
Yes. It was handled fairly restrictively, I think.
It was.
Yes.
It was. But, well, certainly it's in accordance with practice for law officers to receive political comments from their colleagues on the consequences of, for example, mounting a prosecution, and they can take those considerations into account. That's the only analogy I can think of. I'm not myself aware of a previous precedent for this. I have to say that I was surprised when I saw
surprised that he gave it,
the process,
handed it over in draft, and with a very restricted circulation.
Yes.
Yes. Okay. Thank you very much.
Thank you. I think that brings us almost to the end. I've got one very general question, which you may perfectly reasonably decline to respond to. It follows from a question that Baroness Prashar was asking, and I don't want to press further on your personal decision to resign or retire, but it's rather the more general thing. In a parliamentary democracy, ministers decide and must carry, if they can, the House of Commons. Should they, in forming their decisions, pay special regard, and if so, how much, to professional opinion as opposed to policy advice by professional, including legal, medical, statistical, perhaps military? Or should they accord it absolute respect and deference? And I'm not trying to lay a trap, but, and I'll expose the final point, which is there a difference between their professional advisers and the weight that ministers should attach to that advice, and in this special case, the formal opinion of the Attorney General?
I don't want to answer your question right across the board, because I can't have anything to say about economists or statisticians or other professional advice. On the law, you are, of course, up against various constraints, like what used to be in the ministerial code, what is in the rules of engagement of our forces, what is in no doubt, the financial requirements of the civil service, which all require, in some sense, legality to be there. And so in that sense, at least, it would be advisable for ministers to attach particular importance to legal advice. That's the bottom line. I would like to say that for the reasons we were saying, that it's in the interests of the United Kingdom to comply with international law, that one ought to make a particular effort to keep within that.
One last attempt to tempt, if I may. Should, therefore, a government contemplating this very serious course of action continue to rely, as historically governments have, on the convention that the Attorney General's opinion in the matter is final and beyond argument? It is a convention.
I think that the process that was followed in this case was lamentable, and there should have been a greater transparency within government about the evolving legal advice, so that it wasn't left entirely to the Attorney General alone, right at the end, to have the say.
Thank you. Is there any final or other comment you would like to offer before we close this session?
I think we've covered all the points I wanted to make.
Good.
Thank you.
Well, can I thank our witness very much, both for your statement and also for your evidence this afternoon.